very honored to be joining you here tonight. I really appreciate Cameron and Carter getting this whole thing started. Intellectual diversity is really important, and this is a really important contribution to intellectual diversity. Please bear with me as to my appearance tonight. I'm not disrespecting the event. I have a recent surgery on my arm, and I can't bend it enough to tie ties or button buttons, so I have to dress like this tonight. I hope you'll forgive me for that. I'm honored to share the stage here with our worthy opponents. Professor Mike Domino is a professor at Widener University Commonwealth Law School in Pennsylvania. He's graciously agreed to visit with us here this semester and take on a weighty teaching load to help us out. Mike's expertise is directly relevant to our proposition tonight as he focuses his academic work on the law, on the constitutional law of elections and politics. And then we have Grant Majors, who I've taught myself and has thoroughly impressed me. I judge him to be a law student of the highest caliber and integrity, a current 2L at our school. Please give a hand to my opponents this evening. So thank you to Cameron for that excellent summary of the Supreme Court's decision. And with that, I'm free to begin my portion of the discussion in favor of the proposition. So, my portion is simply this. The decision in Trump versus the United States is not defensible on any objective constitutional interpretive ground. It can only be defended on a non-objective ground, and that non-objective ground itself is not defensible. So, let me begin. The first objective ground that any constitutional interpreter uses is the text of the Constitution. We have a couple of portions of the Constitution's text that are directly relevant to the proposition and directly relevant to the Trump versus United States case. The first is the Impeachments Clause, which says that the President, along with several other officers in the executive branch, shall be removed from office on impeachment for and conviction of treason, bribery, and other high crimes and misdemeanors. The more important clause is actually not in Article 2, which deals with the President, but is in Article 1, and it's called the Impeachment Judgments Clause. This clause says, judgment in cases of impeachment shall not extend farther than to removal from office and disqualification to hold and enjoy any office of honor, trust, or profit under the United States. But the party convicted shall nevertheless be liable and subject to indictment, trial, judgment, and punishment according to law. So this is what I would call an election of remedies provision, or maybe an anti-election of remedies provision. What it specifies for us is that even if a president is impeached, the president remains liable under the criminal law for indictment and trial and punishment. In other words, if a president is impeached and convicted in the impeachment, double jeopardy does not attach. Prosecution can still go forward. That is the way that the clause was understood at the time, and that is the way that the clause reads when you read it most straightforwardly. The court addresses this clause in a couple of places in its opinion, but it does not feature prominently in the court's opinion, which is really striking, considering that the text is usually where all constitutional interpretation starts. First, the court says, by its own terms, the clause does not address whether and on what conduct a president may be prosecuted if he was never impeached and convicted. But then the court goes on correctly to hold that impeachment is not a prerequisite to prosecution. Aaron Burr was vice president and was prosecuted without being impeached. Judge Walter Nixon, not Richard Nixon, Judge Walter Nixon was prosecuted and then impeached. Prosecution and impeachment can happen in any order and have over the course of our history. So the court was correct in that decision. However, the Impeachment Judgments Clause clearly specifies what the president can be prosecuted for by using the term according to law, which traces back to Magna Carta. And the notion of being prosecuted according to law stems from the Law of the Land Clause of the Magna Carta and was adopted into our current Constitution through an unbroken line of understanding that says that prosecutions can't happen unless a legitimate legal process has made a thing into a crime. Crimes cannot be prosecuted ad hoc, in other words, by the whims of an executive. And so there's no confusion about what the president can be prosecuted for, any crime. And in response to the dissent, the court says this, but that clause, the Impeachment Judgments Clause, does not indicate whether a former president may be consistent with the separation of powers, be prosecuted for his official conduct in particular. It's difficult to understand how the court can read the clause this way. It certainly addresses whether a president can be prosecuted. And by ensuring that impeachment doesn't operate as an attachment of double jeopardy and thereby prevent further prosecution, it shows pretty clearly that the same official conduct that justified the impeachment can also be the conduct that justifies the prosecution, thereby pretty much explicitly saying that prosecution can occur for one's official acts. Generally, impeachment is what occurs for one's official acts, and the Constitution doesn't draw any distinction between those two. So, I'm baffled that the Chief Justice could read the clause that way. So that's the text, and then we have the structure, and I think the structure is as compelling as the text in this circumstance. So in Article 1, we have the speech or debate clause. The speech or debate clause says, among other things, it says that senators and representatives shall be privileged from, among other things, arrest for any speech or debate in either house. They shall not be questioned in any other place. I kind of mangled that a little bit, but the important part is legislators are absolutely immune from criminal or civil proceedings for their speech and debate and activities related to the speech and debate in Congress. Right? Now, why do I focus on that when this question is about the president? I focus on that because there is no similar provision, nothing remotely similar to it in Article 2, which is the article that deals with the president. The Constitutional Convention knew how to grant absolute immunity, and it did so to Congress, and it did not do so to the president or to the judiciary. So the obvious interpretation that is warranted here as a result is that the conventioneers did not mean for the president to be immune from prosecution or immune from anything else, for that matter. There's a good historical reason for this difference in treatment. I think it's worth noting this. In the 16th and 17th century, it was fairly common for the English monarch to threaten or otherwise pressure members of Parliament by either threatening or even accomplishing arrest of those members of Parliament for acting in ways that the monarch did not like. And so, as a result, the English Bill of Rights in 1689 specified something remarkably similar to the speech and debate clause. It says this: the freedom of speech and debates and proceedings in Parliament ought not to be impeached or questioned in any court or place out of Parliament. So we drew our speech and debate clause directly from that history. And the most compelling conclusion from that is that the constitutional drafters, in enacting the speech and debate clause, were trying to solve a very particular problem of which they were very clearly aware, and to prevent that problem from arising in their new republic. And they did not do anything similar for the executive. Why didn't they do anything similar for the executive? Because the executive was the one that they were worried about. The monarch in England was the one who used to threaten members of Parliament, not the Parliament members, and not any members who worked with the Parliament members. The monarch did that. The king is who they were worried about. They were worried about the president becoming a king, acting like a king. So they gave legislators immunity from that sort of a truly worrisome kingly power, and did not give that same immunity to the president. The structure of the Constitution indicates that immunity is not warranted for the president. The next thing that and there's one other element of structure, and it's a minor point, and that is that in Article 2, we have a provision called the Take Care Clause, which says that the president shall take care that the laws be faithfully executed. This is a placement of a fiduciary duty on the president to act in good faith in enforcing the laws. It's strange reason that we would place this provision into Article 2 on the assumption that the person who is bound by that fiduciary duty is not also bound by the law himself. That's a small point, but I think it's an important point structurally. History is the next thing that we look at, particularly this set of justices in this court is another, has used history in a number of places. There's a historian's amicus brief in this case, and the court really didn't pay any attention to it, but in that historian's amicus brief, the historians made the rather straightforward claim that the founders were completely uniform in believing that the president was subject to law just like any other citizen, even though they disagreed on some aspects of the notion of impeachment. Some of them even didn't think we should have impeachment. But they all agreed that the president would be subject to law just like any other citizen. They say that the historical claim to the contrary is just not credible from a historical perspective. Now, I think this is refreshing to get actual history in the Supreme Court in interpreting the Constitution, because often we get armchair lawyer history in interpreting the Constitution. Getting history from actual historians is something we should pay attention to, and the court didn't really give it much attention in developing its standards. So we all know from our studies of history that there were opponents to the ratification of the Constitution, and some of these opponents, many of these opponents, were opponents of it because they were worried that the executive power was too broad. And Alexander Hamilton spent a good bit of time in the Federalist Papers arguing against these objections. And several of these Federalist Papers are relevant to the case before the court. Oddly, Chief Justice Roberts, who wrote the opinion, gestures at these really relevant provisions, but pulls what I call sprinkle quotes, quotes that can be sprinkled into another context, from Federalist 70. The sprinkle quotes he pulls are that the executive, that we have set up an executive branch so that will be vigorous and energetic. He pulls those two terms out and makes a great deal out of them in saying that the president should be uniquely powerful in some way. Federalist 70 is not about how powerful the president is, it's about how effective the president is. It argues for a single executive rather than a committee. That's all it does. It's not making any grand claims about presidential authority. Hamilton uses the words vigorous and energetic as synonyms of effective. And that's completely unsurprising given Hamilton's penchant for poetic license, poetic expression. He was well known for that. So, and also, of course, words, adjectives in particular at the time of the founding often meant things that were slightly different from how we would understand them today. And we have to really guard against anachronistically interpreting those sorts of adjectives. We have to look at them in context and see what they're being used for. Here they're being used to show that it would be better to have a single executive with a lot of advisors than to have a bunch of equal executives who can all constantly squabble and overrule each other, right? The more relevant Federalist Papers include Federalist 69, where Hamilton reminded the people of New York that the president can be removed from office and would afterwards be liable for prosecution and punishment in the ordinary course of law. Federalist 77 sums up Hamilton's arguments in Federalist 67 to 77 and says, I endeavor to show that as far as Republican principles will admit, the presidency has all the requisites to energy. The remaining inquiry is, does it also combine the requisites to safety in a Republican sense, otherwise a fiduciary sense, a due dependence on the people, a due responsibility. And he says, from the election of the president once in 4 years by persons immediately chosen by the people for that purpose, and from his being at all times liable to impeachment, trial, and dismission from office, incapacity to serve in any other, and to forfeiture of life and estate by subsequent prosecution in the common course of law. So, reading this together, Hamilton, one of the most important founders and the most prolific author of the Federalist Papers arguing for the ratification of the Constitution, for him, liability for impeachment and prosecution for potentially the same conduct is a vital precondition to the president being responsible to the people. It's a vital precondition to enforcing the president's fiduciary duty to the people. Roberts doesn't deal with this clear statement at all. And finally, Federalist 65 defends the decision to lodge the trial of impeachments with the Senate rather than the Supreme Court, and concludes with this point. The punishment which may be the consequence of conviction upon impeachment is not to terminate the chastisement of the offender. He will still be liable to prosecution and punishment in the ordinary course of law. So perhaps even more telling than these other quotes, by using the word still, Hamilton here indicates that the president, even prior to impeachment, is liable to criminal law, and that he remains so following an impeachment and conviction. In other words, double jeopardy does not attach. The text means what the text says. The historian's amicus brief lists several other contemporaneous statements that all run in the same direction. Not a single important thinker at the time of the founding considered the president immune from criminal prosecution. Quite the opposite, in fact. What they worried about most was the president's abuse of his official office to commit crimes or enrich himself. And they laid out two non-exclusive options to control such abuse: impeachment and prosecution after leaving office. Contemporary understandings of those at the highest level of our government, sometimes we rely on those. President Ford's pardon of Nixon assumes he's liable for criminal prosecution. President Clinton's non-prosecution deal assumes he will be prosecuted if he does not enter into that deal. He made a deal with the independent counsel and with the Arkansas bar. Senate Majority Leader's Mitch McConnell's justification for not voting to convict former President Trump did so on the explicit ground that President Trump would get his comeuppance potentially through civil or criminal proceedings, and that he was not immune from either. He explicitly said that. Simply put, the notion that a former president of the United States might be immune from consequences for his criminal official behavior has never been part of the public understanding until Trump's own lawyers made it so by making what was then viewed as a frivolous argument. Now, I'm coming up on the end of my time, and I ate up some of it by thanking and everything like that, so if you give me a moment of license to conclude by setting up my colleague here. The court relies on two mechanisms to define or to develop the idea that the president should be either absolutely or presumptively immune. One is precedent. The primary precedent the court relies on is Nixon versus Fitzgerald, which recognized an absolute immunity of the president for claims against claims for damages in civil court. I will say briefly that this case doesn't speak to criminal immunity at all, and civil liability for damages occupies a special place in the law of immunity. Recognizing immunity from civil claims for damages does not even exempt the president from claims for injunctive relief. As a matter of fact, the current Supreme Court has enjoined the current president several times. There's no dispute about that. So I would encourage everyone not to take Fitzgerald any further than what it decided. It doesn't really extend further than what it decided. Secondly, and really most prominently, the Chief Justice engages in a lengthy consequentialist policy analysis indicating that immunity is essentially a good idea and therefore we should have it. The centerpiece of this good idea is that absent immunity, the president will not be able to take bold and fearless action or vigorous and energetic action. I'll pose two questions here and then I'll conclude. Okay? One, in what world would we want a president to take action before deliberating? There are vanishingly rare circumstances in which a president would have to act in the way that a police officer has to act when he effectuates an arrest of a violent suspect. A president is just not similarly situated to that type of a person. We don't need the president to be bold and fearless. We need the president to be deliberative and wise and to take care in his decisions. He's surrounded by an army of advisors and lawyers. We want him to take advantage of that. Okay? And then two, who would the president have to worry about being prosecuted by? Only the next president or some president down the line. Now, until recently, that has never happened in American history. And the recent prosecutions all resulted from indictments, 2 at the state level and 2 at the federal level, by juries of the former president's peers, through the process that protects every single criminal defendant that has ever come through the system for a serious crime. And I would ask you whether we should allow speculation about illegitimate prosecution to override the important protections that apply to you, me, everyone else, and the president. That's the way the founders would have wanted, and that's the way we should have. I encourage you to vote yes on the proposition, and I yield the floor to my worthy opponent.